Come to order, please. Good morning, everybody, and welcome to the Superior Court of Teasley Middle School. My name is John Klein. I am a member of the Teasley Middle School class of 1988. Now, I've been appointed by the Chief Judge of this court, the Honorable Fred Forsch, who some of you may know, to serve as Judge Pro Tem for today's session of court. The court will now call the matter of the state versus the caretaker, which is case number 2016-TMS-1843. This case is before the court for a criminal jury trial. Now, based on my review of the record, it appears that the defendant in this case, the caretaker, has been charged with first-degree murder in connection with the death of the old man. As I understand it, the caretaker has entered a plea of not guilty by reason of insanity. Now, is the state ready to proceed with trial this morning?
Yes, Your Honor.
Okay. And is the defense also ready to proceed?
Yes, Your Honor.
All right. Now, as I mentioned at the outset, this case is before the court for a jury trial. Jurors are members of the community who hear cases and decide what the actual facts of the cases are. For the benefit of the members of the public who are with us here today and seated in the gallery, I would note that jury selection has already taken place in this case, and that our jurors have already been seated over here in the jury box. Now, members of the jury, let me begin by thanking you for your service as jurors. You play a vital role in the functioning of our legal system, and you help make the American legal system the envy of the world in terms of other ways of adjudicating disputes. I'd like to give everybody a quick overview of how today's trial will be conducted, and the trial will be conducted in 3 segments. The first segment is called the opening statement. Each side will be given an opportunity to give a brief overview of what they think the case is about and to tell you, the jurors, what they believe the evidence will show. The state will go first, followed by the defense. But you should keep in mind, jurors, that the information that you hear in the opening statement is not evidence and should not be considered as such. It's just an outline of what each side believes the evidence will be. The second segment in the case is the presentation of evidence. Each side will have an opportunity to call witnesses who will testify as to what they know about the passing of the old man and about the mental state of the caretaker, the defendant, around the time of the incident. Since the state bears the burden of proof in this and every other criminal case, they will present their evidence first, and then once the state rests their case, it will be the defense's turn to present their evidence. Each witness will face 2 rounds of questioning. First, the witness will be questioned by the side that called him or her to the stand, which is called direct examination. Then, the opposing side will have a brief opportunity to question the witness as well, and this is called cross-examination. The third segment of the trial is called the closing argument. In this phase, both sides are given a final opportunity to explain how the evidence presented through the witnesses fits together in the overall picture, and an opportunity to persuade you to render a verdict on their side. Since the state bears the burden of proof in this and any other criminal case, the state can choose whether they want to make their closing argument first or whether they want the defense to go first. After closing arguments, you as jurors will be asked to deliberate on the evidence heard in the trial and to render a verdict, either finding that the caretaker is guilty of the crime of first-degree murder or finding that the caretaker is not guilty by reason of insanity. Now, attorneys, are there any issues that we need to address before we get started with the trial?
All witnesses have been constructively sworn in. All parties have been stipulated to exhibits.
Okay. Any other issues? All right. Then with that, we will we'll begin with opening statements. On behalf of the state.
Hello, I'm Mary Stewart Branham. First, I would like to thank the jury and Judge Klein for coming out today. On December 12, 1843, around midnight, we will show that the caretaker entered the old man's room and murdered him. The case before you is the matter of state versus the caretaker. The prosecution will prove to you beyond a reasonable doubt that the caretaker committed premeditated murder of the first degree. The state would note to the jury that the defendant planned the murder for a total of 8 nights. The defense will argue that the caretaker didn't know what he was doing on those 8 nights and that he couldn't control his actions, but we would ask that you remember how long the murder was planned. After evidence is presented at the closing of this trial, the state would ask that you find the caretaker guilty.
All right. Thank you, Ms. Brown. Is there an opening statement on behalf of the defendant in this case?
Yes, Your Honor.
All right, Ms. Muller.
Thank you for being here today. My name is Audrey Mullen. I am the lead attorney for the defense. With me today I have Bennett Ohm, Aurelie Lopez, and Jeanette Pinata. The state has charged our client with the crime of murder. The state will argue that my client should be found guilty of this crime because he knew what he was doing. Today my team will prove that the caretaker was not in control of his actions during the time of the crime and that he is insane. You will hear in his statements to police that the defendant has admitted to the crime, but you will also hear that the defendant clearly stated he has heard voices and the beating of a dead man's heart. We will prove that the defendant should not be found guilty due to insanity and ask the jury at the end of this trial to find the defendant not guilty.
All right, thank you, Ms. Mullen. I would like to note for the record that we have invoked what's called the rule of sequestration here today. That means that all of the witnesses who are going to testify are not permitted to remain in the courtroom while the other witnesses are testifying until after they have already had their turn on the stand. The reason that this rule exists is because you do not want a witness who hears what comes from the witness stand and then changes his or her story to take into account something else that's been heard. So that's a very typical thing that is done in court situations, and we've done that as well here. All right, we'll start with the state's presentation of evidence, and you can call your first witness.
I would like to call Victoria Cantrell to the stand.
All right, Victoria Cantrell, is there someone who can fetch Ms. Cantrell? All right, Ms. Cantrell, if you would step around to the witness stand and go ahead and take a seat. And Ms. Oliveris, you can proceed with question.
Are you familiar with the old man?
Yes, he is my neighbor.
Were you at home the night of December 22nd?
Yes, I was with my 3 siblings.
Did you hear or see anything unusual that night?
Yes, around midnight I heard a shriek.
What did you think was happening when you heard the shriek?
I thought the man was having another heart attack.
What did you do after the shriek?
I called 911.
What did you tell the police when you called them after the shriek?
I stated that the shriek was terrifying and I was worried about the old man.
Have you ever noticed any weird actions within the narrator the week of the old man's death?
No, he was acting completely normal.
During all these years you've lived next to the narrator and the old man, have they been friendly or cruel to each other?
They have been very friendly to each other.
During all these years you've lived next to the narrator, have you ever felt unsafe?
No,
What kind of relationship did you have with the narrator and the old man?
we were nothing more than just friends.
No further questions.
All right, thank you, Ms. Oliveris. Is there any cross-examination for Ms. Cantrell?
No, Your Honor.
Questions? Okay. All right, Ms. Cantrell, thank you very much for appearing. You can step down. You are welcome to remain in the courtroom if you'd like, since you have already completed your testimony. All right, State, you can call your next witness.
I'd like to call Officer Josh Vickers to the stand.
All right, is there an Officer Vickers who's here? Officer Vickers? All right, Officer Vickers, if you will step around to the witness stand here and just have a seat. And then Ms. Harn, you can proceed with your questioning of the witness.
Please state your name and occupation.
Officer Josh Vickers.
Were you on patrol the night of December 12th, 1843?
Yes, I responded to a 911 call at the old man's house around midnight.
What did you observe when you arrived?
The defendant welcomed us in, gave us chairs, and started a conversation.
Was there anything strange going on when examining or questioning the narrator?
No, he wasn't acting strange.
No further questions.
All right. Defense, are there any questions for Officer Vickers on cross-examination?
No, Your Honor.
Is there additional direct? All right. Then, all right, any questions for this witness?
No, Your Honor.
Okay. All right, Officer Vickers, you can step down. Thank you for being here. You are free to remain in the courtroom if you'd like to observe the remainder of the trial. All right, State, you can call your next witness.
If it pleases the court, at this time I would like to call Officer Nate Smith to the stand.
All right, Officer Nate Smith. All right, Mr. Smith, if you would step around and take a seat at the witness stand here. All right, Ms. Harn, you can proceed.
Please state your name for the jury.
Officer Nate Smith,
What is your occupation / profession?
Chief of Police.
How long have you been a police officer?
About 20 years.
Did you read the caretaker the Miranda rights?
Yes, I did.
What did you see upon arrival to the house?
Everything seemed to be normal. Your defendant answered the door and invited us in to have tea. He seemed to be quite normal and very inviting as the night went on. He started to talk faster.
When the caretaker confessed to the crime, in your opinion, did he seem to be acting sane?
Yes, he did.
Was the interview recorded that night?
Yes.
At this time, I would like to play Prosecution Exhibit 1.
All right. Sorry about that.
Guys, assemble the four! I am here! It is the beating of his hideous heart.
Is this true and accurate representation of the defendant's demeanor during your interview?
Yes.
No further questions.
All right. Defense, any questions for this witness?
Yes, Your Honor.
All right. Proceed, Mr. Rowland.
As the night went on, how did the mood of the caretaker change?
He began to talk on a fluent and higher voice. Then began to say that he heard a heartbeat, which led him to confessing the murder of the old man.
Did you at any time hear a heart beating?
No, I did not.
What were the narrator's actions like while you and the other officers sat down with him?
He was pretty normal, but as the night went on, he talked faster into height of adrenaline and excitement.
Did he appear to be acting strange and or jittery?
Yes. He did come here.
What did you see when you entered the house?
Everything looked normal and everything was in place, and he invited me to talk, and when he did that, I did not see anything wrong.
How many officers were there to witness what happened that night?
2.
What made the caretaker confess to the killing of the old man?
He appeared to believe that we heard the heart of the old man beat when we were mocking him.
Can you please tell the jury any statements that the defendant made during your interview?
He said, yeah, he killed the old man, and his exact words, "Villains, assemble no more, I admit the deed, tear up the planks, here is the beating of his hideous heart."
At this time, I would like to play Defense Exhibit 1.
It is impossible to say how the first idea entered my brain, but once convinced, it haunted me day and night. Object there was none, passion there was none. I loved the old man. He had never wronged me. He had never given me an assault. For his gold I had no desire. I think it was his eye. Yes, it was this. He had the eye of a vulture, a pale blue eye with the film over it. Whenever it fell upon me, my blood ran cold, and so by degrees, very gradually, I made up my mind to take the life of the old man and thus rid myself of the eye forever.
Is this video a true representation of the other parts of the video that the prosecution did not show?
Yes.
Based on this clip, would you say that a sane person would act like this?
I'm not sure.
No further questions.
All right. All right, thank you, Officer Smith. You can step down. All right, State, you can call your next witness.
I'd like to call Hannah Knight to the stand.
Hannah Knight, please. Hannah Knight. All right, let's not if you step around and just have a seat at the witness stand here. All right, that's Mr. Leshin, is that correct? All right, Mr. Leshin, you can proceed.
Can you give the court your full name?
And I'm a Smith.
What is your profession?
I'm a psychiatrist and I've been practicing for 5 years.
Did you interview the defendant?
Yes, I did. 2 sessions, 4 hours each.
Did you make any observations in your interview?
He was calm and able to remember everything during the interview.
Can you give the legal definition of insanity?
In my professional opinion, the definition of insanity is when you can't tell the difference from reality or fantasy, and you are also not able to control your actions.
After reviewing the police report, Did you believe that the defendant was in control of himself that night?
In my professional opinion, he was able to control himself over what he was doing to the old man and knows what he did to him as well.
When you tested on his medical standards, did he have any drugs on him or anything that would make him go mentally insane?
During our sessions, he did not have any drugs nor mental illness that would cause him to go insane.
When you ran tests on the defendant, did he try to harm you or threaten you in any way?
When I ran tests on him and assessments, he did not try to harm me.
Based on your evaluation on the defendant, what is your opinion?
He was sane at the time of the murder.
There is no further questions.
All right. Defense, any cross-examination for Dr. Knight?
Yes, Your Honor.
Ms. Mullin, go ahead.
You've been a psychiatrist for 5 years, correct?
Yes.
And you've only met with my client for 2 sessions of 4 hours each.
Yes.
And you've only testified in court 5 times.
Yes.
How does this qualify you to declare this man insane?
I went to medical school for 5 years and got a master's degree, and then I got an internship at a psychiatrist for 3 years.
No further questions.
All right, Dr. Knight, thank you for being here. You can step down. You're welcome to remain in the courtroom if you like, or you can go about your business. I mean, you probably have other patients that are waiting on you at your office, so we appreciate you.
Thank you.
All right, State, any other witnesses you wish to call?
No, Your Honor.
All right, so the state having rested, that brings us to the defense's presentation of evidence. Defense, you can call your first witness.
I would like to call Matthew, the caretaker, on this matter.
All right, Matthew the caretaker, if you come around for us, please, sir. You can have a seat for witness stand. All right, and the witness is with you. You can proceed.
Please state your name. The caretaker. What did you do? I murdered the old man. Why did you do it? Because of the old man's ulcer. How did you do it? I suffocated him and then cut up the body.
Well, wasn't there a lot of blood?
I drained the blood in the cup
Where did you hide the body?
under the floorboards.
What happened next?
The police knocked on the door.
And what happened after that?
I let them in and gave them a tour of the house.
What did you tell the police?
The old man was out of town and the shriek they heard was merely mine from a nightmare I had.
Why did you confess the murder?
Because the heart was mocking me with its heedless beating.
Was the heart beating?
Yes, it mocked me as it beat.
On the night of December 12, 1843, why were you so intrigued by the old man's eye?
It made my blood run cold and made me mad.
Why were you so nice to him when morning came, but at night you gazed upon him with hatred?
Because I wanted to reassure the old man that everything was okay.
Why was murder an option to you?
Because I felt that was the only way to get rid of the Volturi was to also kill the man who had the Volturi.
Why hide the body underneath the floorboards?
Because I wanted to get rid of the evil Volturi for good.
What were your thoughts as you suffocated the old man?
I finally stopped the Volturi.
All right, cross-examination. Ms. Brown, you can proceed.
You remember when you killed the old man, correct?
Yes.
Is it true that you waited over an hour before deciding to attack?
Yes.
When taken in for questioning, is it true that you felt angry and confident?
Yes.
Is it true that you waited for 8 nights?
Yes.
Is it true that you planned over those 8 nights?
Yes.
No further questions.
All right, you can step down, sir. Thank you, Mr. Caretaker. Defense, you can call your next witness. All right, Jasmine Perez, please. All right, Ms. Perez, if you would step around to the witness stand over here. Be careful of the wires. You've got a few that are running across where you're going to walk. Just be seated. All right, Mr. Ray, you can begin your question.
What is your name? Jasmine Perez.
What is your profession?
I'm a psychiatrist.
How long have you been working in this profession?
25 years.
Is it correct you previously worked at the state of Maryland as a staff psychiatrist?
Yes.
Is it true that they have been a leader in treatment and care for the mentally ill patients?
Yes.
So you work with and know how to identify someone with a mental disability as you work with them daily?
Yes.
Would you, in your most professional opinion, find the defendant insane at the time of the crime?
Yes.
I have no further questions.
All right, you just remain where you are. Maybe the state has questions for you. Any questions for this witness?
No, Your Honor.
All right, Dr. Fresh, you can step down. You're free to remain in the courtroom if you like, or if you want to get back to the office, you're free to do that as well. But thank you for being here. All right, defense, you can call your next witness.
I would like to call Mackenzie Hatcher.
All right, Mackenzie Hatcher, please. Mackenzie Hatcher. All right, Ms. Hatcher, if you would step on over to the witness stand and just be seated. Let's see, and Ms. Lopez. All right, Ms. Lopez, you can proceed.
Please state your name. Mackenzie Hatcher. Are you familiar with the caretaker? Yes, he's my neighbor. When you first met him, how would you describe him?
He was quiet and nice.
Did he ever get severely sick?
Yes, 2 years ago he got sick.
Would you describe him? How would you describe him after his sickness? As being much different?
Yes.
Did this sickness seem to affect his work or personality?
Yes, he got fired after skipping work.
Did he seem to act irrationally after the sickness?
Yes, he was very emotional and hyper.
Do you think that this emotional instability, coupled with the hyperactivity, could cause him to act out on something that upset him in the moment?
Yes.
No further questions.
All right, State, any questions for this witness? No? Okay. All right, Ms. Hatcher, you can step down. Thank you for being here. You're free to go about your business. If you'd like to remain in the gallery for the rest of the trial, you're free to do that, or you're free to go, just whatever works best.
Thank you.
All right. State, you can call your next witness. I'm sorry, defense, you can call your next witness.
I would like to call Chase Smith.
All right, Chase Smith. All right, Mr. Smith, you can step on over to the witness stand here and have a seat. All right, the witness is with you.
Please state your name.
Chase Smith.
What is your occupation?
I'm a police officer for the Teasley Police Department.
At what time did you enter the home of the caretaker?
We received the call at midnight, but we didn't enter until 12:15 on December 22nd.
All right. Do you notice any odd behavior from the caretaker?
He kept talking about a vulture eye and hearing a beating heart.
Did his behavior seem odd to you?
He grew very pale, talked fluently with a heightened voice.
Would you say that he seemed sane while you were talking to him?
Well, I'm not sure that I would call that sane.
Did you hear the heart beating just as the caretaker said?
I did not.
Tell me about his behavior when he confessed to the murder.
When he confessed to the murder, he threw chairs and said, "Villains," I shrieked, "dissemble no more. I admit the deed. Tear up the planks. Hear, hear. It is the beating of his hideous heart."
No further questions.
All right, any questions from the state for this witness?
No, Your Honor.
All right, you can sit down, sir. Thank you for being here for the trial. You're free to go back to business. You can remain in the courtroom if you'd like, and you can if you will on your way back. All right. Defense, are there any other witnesses you wish to call?
No, Your Honor.
Okay. All right, members of the jury, we have now reached the conclusion of the evidence, which means it is time for the third segment of the trial that I was telling you about earlier, which is the closing argument. As I mentioned earlier, the state bears the burden of proof in a criminal case, so they have the right to choose whether they will go first or last in closing argument. State, do you want to present your closing argument first, or do you want the defense to go first?
First.
Okay. All right, then, State, you can present your closing argument this time. Ms. Collins, go ahead.
The defendant planned the night for a total of 8 nights. The defense would have you believe that their client didn't know what he was doing on those 8 nights and that he couldn't control his actions. But if he was in fact insane, he would commit the crime on the first night and not taking so much time to do it. He painstakingly thought through every aspect of the crime, making sure every moment counted. How then is he insane? Would a victim of mental illness have the foresight that this man had performed his almost perfect murder? The defense may state that he suffers from paranoid schizophrenia. We demonstrate to you that that is not the case. One of the symptoms of this illness is memory loss, which means that if the defendant were insane during the night of the crime, he wouldn't have been able to tell us what he remembered from the night of the crime. The defendant stated multiple times that he's in fact not insane. The defendant stated, "You should have seen me. You should have seen how wildly I proceeded, with what caution, with what foresight, with what dissimulation I went to work." The state would like to ask you to find the defendant guilty of murder of the first degree. Thank you for your time.
All right, thank you, Ms. Collins. All right, is there a closing argument on behalf of the defense?
Yes, Your Honor.
All right. Ms. Mullen, you can proceed.
During this case, we have proven using the evidence that we have gathered that the caretaker is insane. A few pieces of this evidence would be that he could hear voices, that he killed a man that he clearly stated that he loved, and how he claims to have heard the beating of a dead man's heart. Even though the caretaker has committed a terrible crime, he cannot be held accountable due to the fact that he could not control his actions. We believe him to have some form of schizophrenia. A person with schizophrenia would not be in a sound state of mind. The definition of insanity is not knowing right from wrong. By this definition, he was insane due to the fact that he could not see that murdering someone is wrong. As for the response to the prosecution, memory loss is a symptom, and not all symptoms are shown, even if a patient does have an illness. I hope you can see that the caretaker is not guilty of his actions and find my client not guilty.
All right, thank you, Ms. Mullen. All right, members of the jury, you've now heard the evidence in the case, and in just a minute you'll be asked to deliberate over the evidence and render a verdict. Before you do that, however, I'd like to give you a few brief instructions, so I would appreciate if you would listen carefully for the next moments. The defendant in this case, the caretaker, has been charged with first-degree murder in the death of the old man. The caretaker does not dispute the fact that he killed the old man on the night in question. However, the caretaker contends that he should be found not guilty by reason of insanity. The duty of the jury in this case is to determine if the defendant is guilty of the crime of first-degree murder or is not guilty by reason of insanity. Under applicable law, insanity is a mental illness of such a severe nature that a person cannot distinguish fantasy from reality, cannot manage his or her own affairs, or is subject to uncontrollable impulsive behavior. In this context, not guilty does not mean the person did not commit the act for which he is charged. It means that when the person committed the act, he could not tell right from wrong or could not control his behavior because of severe mental defect or illness. Such a person, the law holds, should not be held criminally responsible for his or her behavior. Under the law that governs this court, the burden is on the state to prove beyond a reasonable doubt that the defendant was sane at the time of the incident. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's sanity, then you have no reasonable doubt, then you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's sanity, then you have a reasonable doubt and you should find the defendant not guilty by reason of insanity. With that, I will ask our bailiff to deliver the jury instructions over to one of the jurors. We'll take it right over there, Ken. And then we will excuse the jury to begin their deliberations. And now we wait. Now in an actual trial, there is no limit on how long the jury can deliberate. So it could be that this phase would be waiting for hours or possibly even days. Oftentimes cases, trials are concluded, usually they try to wrap them up by Friday, but there have been times when we have juries deliberating on Saturdays, Sundays, and they continue to deliberate until such time as they either reach a verdict or until such time as they decide that they cannot agree on a verdict. And does anybody know what happens if they cannot agree on a verdict? Yes?
We take the majority vote.
In a criminal case in this state, they would not take a majority vote. They have to be unanimous. There are other states and other types of charge that might require something less than that, but here they would have to hold out until they're all unanimous. If they cannot reach a unanimous verdict, then the court would declare a mistrial, and then the state would have to decide whether they wanted to try again with a new set of jurors. And sometimes, in a case like this, they probably would decide to try again, but sometimes they decide not to do so. Why don't we take an informal poll while we're waiting on our jurors? Who here in the gallery believes that the state has proven their case that the caretaker was sane at the time of the slaying and therefore should be convicted of the crime of first-degree murder? Anybody? It looks like the state did okay. All right, is there anybody here who has a reasonable doubt about that, who believes that the defendant may have been suffering from a mental illness and therefore should not be held responsible for his actions? We have a couple of folks. All right. Anybody have any questions about anything while we're here? Okay.
First off, really good job so far, guys. Very proud of you. This is the rubric that we're going to be using to overall come together and judge what we've done. We're going to do a self-assessment, assessment of peers. This is going to be your ticket in the door come Monday. So it's out in OneNote. I'll also send you an email this afternoon. We're going to use this rubric to grade this whole process, okay? You guys have any questions about that? So when you come in Monday, have this. I'll have a submission and ask them to have it submitted to you, and we'll talk about it come Monday. Thanks, guys.
So do we have any of our attorneys who think they might actually want to go to law school and be an attorney someday? Anything about Ms. Collins? Possibly. What's that?
My brother wants to be a lawyer.
Okay. Is he older or younger?
Younger.
Okay. All right. Well, for those who think they might want to go to law school, let me give you a word of encouragement. I guess you guys already know sort of how the government is set up. The executive, the legislative, the judicial branches, all that kind of stuff. Can anybody tell me what the highest court in the state of Georgia is? Anybody? It's called the, yes, back in the back.
The Georgia Supreme Court?
Yes, the Georgia Supreme Court. And let me ask you a follow-up question. Are there any graduates of Teasley Middle School who are on the Georgia Supreme Court, which is the highest court in the state?
Yes.
Yes, very good. Judge Keith Blackwell, or Justice Keith Blackwell, came through Teasley in the late 1980s and early, I guess he'd be there, late 80s. He is now a member of the Georgia Supreme Court. There are only, I believe, 7 of those. So that is a very high place to be. And it is proof to all of you that Teasley Middle School is capable of producing somebody who can do unbelievable things. Now, is there anybody who can tell me what is the highest court in the whole country? Yes?
The Federal Supreme Court.
United States Supreme Court. Very good. How many members are there on the United States Supreme Court? Yeah? There's supposed to be 9. Right now there's 8. There's one seat that's open that they're trying to fill. Now, has anybody heard of a man named Donald Trump? Okay.
I love him.
Who is Donald Trump?
Our savior. Potential savior. Potential president. Our savior.
Donald Trump is the Republican nominee for president. We'll be voting on that. We're voting on that now. But Donald Trump has taken the unusual step of going ahead and releasing a list of people who he might consider to be nominees for the Supreme Court of the United States. Again, there are only 9 of those, so that is an extremely high position. It is a lifetime appointment that would affect all of our lives for probably the rest of your life and also affect your children's lives. He has released 20 names of people he might consider to be nominated to the Supreme Court if he is elected. Can anybody tell me how many Teasley Middle School graduates are on Donald Trump's list of the 20 people he might appoint to the highest court in the land? Yes.
2.
That would be great. 1 is plenty. Judge Keith Blackwell, who's currently on the Georgia State Supreme Court, is on the list that Donald Trump has released of people he might appoint to the court. So what that should tell you is if you are at Teasley Middle School and you want to go into law, there is no height that you can't reach from here because there is somebody who is on one of the main presidential candidates list of just 20 people who he would consider for that court. So don't let anybody tell you that because you're from Canton, Georgia, you can't do this, or because you went to Teasley Middle School, you can't do that, because Keith Blackwell is proving that you can. All right. Any questions about anything? All right. Let's come to order, please. Members of the jury understand that you have reached a verdict in this case. Is that correct?
That is correct, Your Honor.
And have you selected a foreperson?
Yes, sir.
Okay. All right. I'll ask the foreperson of the jury to announce the verdict in just a moment. But before I do so, let me caution the members of the public that while the court fully recognizes and appreciates the emotional nature of this case, no outbursts from members of the public will be tolerated when the verdict is read. Now, will the attorneys in the case and the defendant, Mr. Caretaker, please rise and face the jury? Stand, please. Yes, sir, you first. And will the foreperson of the jury please announce the verdict at this time?
Yes, Your Honor. We, the jury, were not able to come to a unanimous decision, and we have to declare that we are a hung jury at this time.
All right. Thank you very much for your service. The attorneys and caretaker, you may now be seated. As you do so, I would like to commend all of our attorneys and our witnesses on both sides on what has been a very difficult case that was very well tried. This is one of the possibilities that I mentioned while the jurors were deliberating, that they would not be able to reach a unanimous conclusion. Defense attorneys would consider that to be a win. So the state would, their client has not been convicted of this act, but the state does have the option of a retrial at some later point in time if they decide that this is a case that they feel strongly enough about that they want to try again with a new set of jurors. Members of the jury, let me again tell you how much I appreciate your service on this case. In just a moment, you'll be excused from further service. I understand that there are some members of the news media who are here and they may want to discuss the case with you, or some of the attorneys or members of the public may also want to discuss the case with you. You are free to discuss the case with them if you choose to do so, but you are not required to discuss the case with anyone. I will order that the defendant in this case will not go to jail for now. He will be free pending further hearing, which will be scheduled at a later date. Again, the court wishes to commend all the attorneys and witnesses on a case that was very well tried. And are there any further instructions?